Are you preparing for the SQE and need a quick introduction to the rules of evidence in the courts and tribunals of England and Wales? You have come to the right place. Let's get right on it. The law of evidence controls the process through which evidence can be admitted and used during trial and the directions that are given by the court to the parties. These rules also set out which party should prove the facts that are an issue in the trial and the standard of proof that must be met in proving them. In English civil procedure, the production and interpretation of evidence is controlled by the court with the aim of meeting the overriding objective of civil litigation. This podcast has been prepared by Dr. ioannis.glinavos and is read out by AI Voices. Get in touch with Ioannis using the information in the description of this video for information on how it was put together. The courts have the power to control and guide the production of evidence in the context of a civil trial. These powers are contained primarily in Rule 32.1 of the Civil Procedure Rules and the relevant practice directions which give practical effect to the rules. A significant consequence of these rules is that the court can override the wishes of the parties as to how they conduct their cases on all aspects of evidence production, including in establishing liability, quantum of damages, and remedies. The Civil Procedure Rules allows the court to impose its own wishes on the parties in relation to the evidence to be called at trial, and this includes restricting the number of witnesses, and especially expert witnesses. The court also gets to determine which evidence is relevant and can restrict the parties as to how facts in issue are to be proved, meaning the use of oral as opposed to written evidence. It is also possible that the court declares inadmissible evidence that otherwise the parties seek to present. This sounds peculiar, but it is necessary to ensure the overriding objective is met. Rule 32 allows the court to exclude in the interests of justice evidence that would otherwise be admissible if there is a danger that doing otherwise will inflate costs and waste time without benefit to the parties and the administration of justice. Considering the significant role the court plays in guiding the trial process, the civil procedure system cannot be deemed any longer adversarial, unlike the criminal one. In this court-managed civil justice environment, the court exercises strict control over the disclosure of documents, the conduct of the trial, and the role of expert witnesses. The judge can control the number of witnesses, the issues upon which evidence is required, and the types of evidence presented. Oral evidence is restricted, and cross-examination is closely controlled. It is important to note that automatic disclosure, this is information being communicated between the parties, is not recognized under the civil procedure rules, and a court order is needed to mandate disclosure. Expert evidence under Part 35 Civil Procedure Rules is also closely controlled and can only be produced by permission of the court. The parties are encouraged to appoint jointly experts to reduce costs and manage court time effectively. It is important to note here that the expert's duty is to the court and not to the parties. This means that an expert has an official role and is required to be nonpartisan. Under Article 6 of the European Convention of Human Rights, litigants have a right to a public hearing and a right to a reasoned decision. While the latter presents no issues in civil litigation in England and Wales, one could argue that the process under the small claims track, usually involving proceedings in the judge's room, may, depending on the circumstances, fall short of the requirement in Article 6. Two key concepts in the law of evidence are relevance and weight. The idea of relevance is central to the law of evidence, as all relevant evidence is in principle admissible, and the relevance of an item of evidence can determine what rules or principles of law govern its admissibility. Lord Simon in DPP v. Kilbourne from 1973 stated that evidence is relevant if it is logically probative or disprobative of some matter which requires proof. Probative suggests a proposition that tends to show that a proposition is true, and disprobative suggests the opposite, that a proposition is false. Weight refers to the probative value of evidence, meaning how valuable it is in helping to support the factual submissions of the parties. Relevance and weight are issues of deliberation and should be distinguished from admissibility, which is a matter of law. As mentioned earlier, in civil trials under the Civil Procedure Rules, the court has a wide discretion under Rule 32 to exclude evidence that is relevant and admissible, so as to secure the overriding objectives defined in Rule 2. For example, in HSBC Asia, Holdings BV versus Gillespie from 2011, Judge Underhill that employment tribunals have the power to exclude evidence which is logically or theoretically relevant, but nevertheless too marginal or otherwise unlikely to assist the court for its admission to be justified. The fundamental purpose of the law of evidence is to provide the ground rules for the litigation process through identifying the facts and issue that each litigant must discharge in order to prove their case to the court. The burden of proof consists of a series of rules that can be presented as the legal burden of proof, the evidential burden of proof, and the standard of proof. The rules and principles of evidence on burdens and standards of proof provide an overarching structure to trials by determining which party has the burden of bringing evidence on which facts before the court, and where a party bears a burden, what test should be applied to determine whether sufficiently weighty evidence has been adduced to discharge the burden. Note that there is an important distinction between discharging the legal burden of proof, which requires a specific standard to be met, and an evidential burden. We will now consider each one of these rules in turn. The legal burden of proof can be described as the onus placed on one party to prove or disprove the facts in issue. The party that bears the legal burden of proof also carries the evidential burden. The general rule is that the party that makes an assertion needs to be able to prove it. The facts of issue are a question of law to be determined by reference to the common law or statute, leading to the creation of a cause of action. For instance, if Gary sues Ellie for breach of contract and Ellie is defending the action by denying liability under the principle of he who asserts must prove in order to succeed, Gary is the one that must prove the following: that a contract existed between Gary and Ellie, what the terms of the contract were, that Ellie. Every time a claimant makes an assertion, they will need to prove it. If in response, the respondent denies an allegation in the claimant's statement of case, the respondent does not have anything to prove. When, however, the respondent denies liability and makes an assertion of their own, for example, Ellie could say that the contract was frustrated, therefore as a matter of law, was not capable of being performed, then the respondent needs to be able to prove their assertion. Once each party is discharged the legal and the evidential burden of proof, the judge will be able to decide based on the evidence presented to support each side's version of the facts and their legal interpretation of these facts. There are, however, certain exceptions to these general rules. In some instances, statute fixes the burden of proof on a specific party. For example, Section 170 of the Consumer Credit Act 1974 places, the burden of credit agreement is not extortionate on the credit provider. The legal burden of proof can also be fixed by agreement of the parties, for example, where the contract stipulates who bears the burden of proving certain matters if they become contentious in the context of litigation. The legal burden of proof will always be ascertained by reference to construction of the relevant statutory provision and any policy considerations. When it is unclear where the burden should lie from the submissions of the parties, the courts will follow the general principle that the burden should fall on the party best able to discharge the legal burden with the least difficulty. This means that sometimes a party may be called upon to prove a positive and sometimes a negative assertion. For example, in the Glendurich from 1894, there was an exclusion clause in a contract for the carriage of goods by sea, excluding liability to the carrier if goods were lost or damaged at sea in the absence of negligence. The owner of the cargo sued for non-delivery, and the carrier responded that the loss was due to perils of the sea. The court declared as to the burden of proof that it was for the owner to show there was a breach of contract, in this case, a failure to deliver the goods, for the carrier to establish that the loss was due to the perils at sea, and for the owner to establish that the loss was due to the carrier's negligence, as the owner made an assertion, not merely a denial. However, in Volcafe Ltd and others, appellants v. Compania Sud Americana de Vapores SA from 2018, the Supreme Court considered that the Glendurich is no longer good law. In this case, the Supreme Court unanimously allowed the appeal, deciding that the legal burden of disproving negligence rests on the carrier. The evidential burden of proof is the practical way in which a person discharges its legal burden of proof by presenting evidence before a court. In other words, the evidential burden is the onus on a party to adduce sufficient evidence to put facts in issue before the court. It is important to clarify that the party that has the legal burden also has the evidential burden on that issue. In civil litigation, the standard of proof refers to the degree of evidence necessary to establish a fact or claim in court. The standard of proof is an essential aspect of civil litigation because it helps to ensure that cases are decided fairly and justly. The standard of proof in civil litigation is typically lower than in criminal cases, where the prosecution must prove guilt beyond a reasonable doubt. In civil cases, the plaintiff must prove their case by a preponderance of the evidence, which means that the evidence is more likely than not to support the plaintiff's claim. The general standard of proof in English law is on a balance of probabilities, which was explained by Lord Denning in Miller v. Minister of Pensions from 1947 as requiring a high degree of probability that something happened, but not as high as required in criminal cases. It is sufficient, therefore, in the context of a civil trial, to prove that the court is convinced that something is more probable to have happened than not. The importance of the standard of proof in civil litigation can be seen in several ways. First, it helps to ensure that cases are decided based on the weight of the evidence. By requiring the claimant to prove their case on the balance of the evidence, the court can make a more informed decision based on the strength of the evidence presented. Second, the standard of proof helps to protect the rights of defendants or respondents. Because the burden of proof is on the claimant, the respondent is unaffected by any demand until proven otherwise. This means that the claimant must present sufficient evidence to convince the court that their demand is valid. Finally, the standard of proof helps to ensure that the legal system is fair and impartial. By requiring a certain level of proof, the court can avoid making decisions based on speculation or conjecture. This helps to promote the rule of law and ensures that cases are decided based on the merits of the evidence presented. There are, however, certain exceptions to this general rule on balance-based standards of proof for civil cases. Committal proceedings for civil contempt of court will need proof at beyond reasonable doubt. Also, statute may set a requirement at that level. Further, as is to be expected, allegations of criminal conduct will require a higher standard than simply more probable than not. The way in which this is expressed, however, is complicated. An example is the case of Hornell v. Neuberger Products Ltd. from 1957, where the Court of Appeal held that where an allegation of a crime is made in civil proceedings, the appropriate standard of proof will be on a balance of probabilities. Lord Morris suggested that the balance of probability does not change, but the seriousness, importance, and impact of the evidence will need to vary according to the seriousness of what is alleged. This enhanced version of the civil standard was confirmed in the case of Re H. from 1996. In summary, the standard of proof is a crucial aspect of civil litigation, as it helps to ensure that cases are decided fairly and justly. By requiring a certain level of evidence, the court can make informed decisions based on the strength of the evidence presented and protect the rights of both claimants and respondents. We now move on to consider certain key aspects of the law of evidence, such as the rules governing documentary evidence, expert testimony, and the use of witness evidence. It also highlights the importance of ethical considerations in relation to the collection and presentation of evidence and the potential consequences of breaching these ethical standards. By understanding the principles and rules that govern the production of evidence, solicitors and other legal professionals can help to ensure that the legal system operates fairly and justly, and that the overriding objective of civil litigation is met. As regards documentary evidence, Part 31 Civil Procedure Rules contains the procedure for the disclosure of documents. Parties to a civil trial are obliged to disclose relevant documents to the other side before the trial commences. There is a positive duty to disclose current or existing documents under the party's control, including documents under physical possession, or where a party has a right to possession, right to inspection, or of making a copy. The proceedings to which the section applies are civil proceedings before any tribunal in relation to which the strict rules of evidence apply, whether as a matter of law or by agreement of the parties. Document and copy have the same meaning, and a party relying on the document can therefore produce the original or any copy, duly authenticated in an approved manner. It should be noted that a wide range of documents is admissible in civil proceedings, since Section 1 of the Civil Evidence Act, 1995 abolished the hearsay rule in civil cases. Admissibility of hearsay evidence. Section 1 Civil Evidence Act 1995 provides that in civil proceedings, evidence shall not be excluded on the ground that is hearsay.
In this act, hearsay means a statement made otherwise than by a person, while giving oral evidence in the proceedings, which is tendered as evidence of the matter stated, and references to hearsay include hearsay of whatever degree.
However, Section 8 of the Civil Evidence Act 1995 refers only to original documents and copies of documents.
It does not allow in terms for the admission of oral evidence of a statement in a document.
It would seem, therefore, that the abolition of the hearsay rule affected by S.1 has not affected the rules about the form in which the contents of admissible documents can be proved. As regards oral evidence of the contents, the common law continues to apply. This is right as a matter of principle. A party relying on a document should be required to explain the absence of the document, or a copy of it, before being permitted to give oral evidence of the contents. Document disclosure can be complicated if relevant documentation is placed in a jurisdiction where discovery of such documents is not allowed.
For example, in the case of Lonerho v. Shell Petroleum from 1980, documents were placed in an overseas jurisdiction and could not be disclosed without the governmental permission of that jurisdiction.
This complicated the position of the litigants before an English court, as they were facing a potential situation of being in contempt in England for not complying with disclosure orders or breaching the law in the foreign jurisdiction. The court accepted that illegality under the law of the country where the documents are located can be a complete excuse for their non-production.
However, this does not mean that parties can be strategic about the placement of documentation they seek to avoid during the discovery process.
On this topic, one can refer to jurisprudence on the so-called blocking statutes, where it became common to make disclosure a criminal offense, where documentation was to be used in foreign court proceedings, principally employed to defeat the assumed universal jurisdiction of U.S. antitrust courts, as, for example, under English courts normally consider that the law of the forum ought to determine disclosure issues. See Judge Hoffman in McKinnon v. Donaldson from 1986.
The purpose of anti-disclosure rules is to protect people from burdensome disclosure requests. See re-asbestos insurance coverage cases from 1985.
Another way to defeat disclosure requests is on grounds of sovereignty. See Rio Tinto v. Westinghouse from 1978. The problem of conflicting requirements also arises when a foreign court asks and for the disclose of information situated in England.
In the case of XAG versus a bank from 1983, the English court allowed a prohibition on disclosure to continue, even when this would result in the bank in the U.S. subject to an order to produce documents to be held in contempt.
The contribution of witnesses can be secured by requesting the court to serve a witness summons, requiring attendance or the production of documents. The rules on witness statements are in Part 32 Civil Procedure Rules. A witness statement is defined in Rule 32 as a statement written and signed by a person which contains the evidence and only that evidence which that person would be allowed to give orally.
There is a link, therefore, between the evidence of a witness and their presence within a courtroom. At trial, every fact that needs proving by the evidence of the witness shall be proved by the witness attending court and giving evidence subject to the discussion of the judge.
The detail on how witness statements are laid out is contained in paragraphs 17 to 22 of the Practice Direction to Part 32 Civil Procedure Rules. An important component of each witness statement is what is known as a statement of truth, as in Rule 32.8 Civil Procedure Rules. This is a statement by the maker that they believe the facts in the statement to be true. Not telling the truth can result in prosecution for contempt of court for making false statements.
An affidavit is a formal sworn statement of fact, signed and witnessed by a notary or similar official. Evidence may be provided by affidavit rather than witness statement in instances, such as those described in Rule 32 Civil Procedure Rules. All witnesses should give sworn evidence before examination. For a witness to be considered competent, they should either take an oath or affirm.
This is very significant, as judgments based on unsworn evidence can be set aside, as in Rule 27. It is worth noting that it is not the divine sanction of lying under oath that is important, but the legal sanction of a conviction for perjury under S.4 of the Oaths Act 1978. Affirmations have the same function as oaths, but are not religious in nature, being based on the honor of the individual making the statement. The civil procedure rules give courts the power to exclude evidence, even when they would otherwise be relevant and admissible if their admission would be contrary to the interests of justice. Some controversy exists over the treatment of improperly obtained evidence.
When the evidence is relevant, it will be admissible, irrespective of whether it has been obtained illegally or unfairly.
A judge can exclude evidence, however, when the impropriety is so grave that to condone it would constitute an abuse of the proper administration of justice.
A relaxed attitude to the provenance of information is also present in the area of hearsay evidence, as we saw earlier. This is information derived from second-hand accounts, and it will generally be deemed admissible in civil courts, except in cases that stray towards criminal issues.
These can involve fraud, defamation, malicious prosecution, and false imprisonment. See Section 69 Supreme Court, Act 1981, County Courts Act 1984. Hearsay evidence is covered by the Civil Evidence Act 1995, which allows it and leaves it up to the judge to assess its value. Opinion evidence is another area that requires specific mention.
The general rule in civil proceedings is that a witness can only provide evidence about the factual matters within their personal knowledge.
Opinions are reserved for the judge or the jury, as the case may be. There are three main areas where opinion evidence is allowed.
When it relates to matters of public concern and family history. For example, witnesses are permitted to give testimony about a party's reputation, conduct, or family tradition, including on the existence of a marriage under Section 7 of the Civil Evidence Act 1995, when evidence is sought on matters within the competence or experience of a lay witness, as will be the case for a witness of a car accident
under Section 3, Civil Evidence Act 1995, and in expert opinion evidence.
The general rule at common law is that witnesses may only give evidence of facts of which they have personal knowledge. In other words, witnesses may testify only as to what they themselves did, said, heard, or witnessed.
The consequences of this rule are found in the hearsay rule, but also in the prohibition of witnesses from expressing their opinions about contested issues and proceedings. In general, witnesses may not draw inferences from the facts or speculate as to the causes of the facts or make value judgments about them. An exception to the opinion rule for expert evidence on matters involving special skill or knowledge has existed for a long time, however. The Law Commission, amongst others, identified several causes for concern with the operation of experts in the context of trials, both in civil and criminal matters. The main problem stems from the fact that a lay jury, which may not be equipped by education or experience properly to evaluate technical or complex scientific evidence, simply defers to the opinion of the specialist on the basis of the witness's qualifications or demeanor, losing sight in the process of their duty to establish.
Expert evidence is addressed by Part 35 Civil Procedure Rules.
Obtaining evidence from experts can be a costly and time-consuming process. As the overriding objective of litigation is the streamlining of civil procedure in the interests of justice, lengthy and expensive submissions by experts should be avoided. Before the Wool reforms, this area of procedure had become a heated one. An expert will be a witness competent to give expert testimony if, in the opinion of the court, they are qualified in the subject calling for their expertise.
The fact that someone is deemed an expert in a particular area, however, does not mean that they can comment on everything relating to the trial. It is a question for the trial judge in each case whether the proposed witness is an expert on the matter that requires special skill, knowledge, or expertise.
It is not always essential that the witness has appropriate professional qualifications or relevant experience. In the majority of cases, professional qualifications or experience will be necessary for the witness to be regarded as an expert.
But they are not always essential.
Under Section 3, Civil Evidence Act 1972, the expert must confine their expertise to their area of specialization.
Experts can only be called with the court's permission rule, 35 Civil Procedure Rules.
As recommended by Lord Wolfe, now under Rule 35 CPR, the court can restrict evidence to what is reasonably required to resolve the proceedings.
Reasonableness here is determined on the basis of the facts and circumstances of the case, and by having regard to the overriding objective of dealing with the case justly. Justly in this context means ensuring that the parties are on an equal footing in terms of their ability to meet expenses and dealing with the case proportionately.
The court can limit the number of experts, restrict the issues for which expert evidence is submitted, direct which expert is to give the evidence when parties choose them together, or nominate an expert when the parties do not agree. Expert fees are restricted, Part 44 to 45, and cannot be recovered from the losing party.
Expert evidence is provided primarily in writing, Rule 35, and Part 1 of the practice direction explains what the expert's report should contain.
Professional ethics are highly relevant to the gathering and production of evidence in court for several reasons. The credibility of evidence and the integrity of the legal system depend on the ethical behavior of those involved in the process. Solicitors, expert witnesses, and other professionals involved in gathering and producing evidence must act with integrity and follow ethical standards to ensure that the evidence presented is reliable and trustworthy. Further, ethical considerations help to ensure that evidence is gathered and presented in a fair and just manner without any bias or discrimination. This is particularly important in criminal as well as civil cases. Ethical standards ensure that the rights of individuals are protected during the evidence gathering process. Also, ethical considerations help to maintain public confidence in the legal system. If professionals involved in gathering and producing evidence fail to act ethically, it can undermine public trust in the legal system and the legitimacy of the outcome of the case. The SRA Code of Conduct for Solicitors describes the standards of professionalism that the SRA and the public expect of individuals authorized to provide legal services. These rules apply to conduct and behavior relating to the practice of law and comprise a framework for ethical and competent practice, which applies irrespective of a legal practitioner's role or the environment or organization in which they work.
Section 2 of the rules deals with dispute resolution and proceedings before courts, tribunals, and inquiries. It specifically requires of solicitors that they do not misuse or tamper with evidence or attempt to do so, do not seek to influence the substance of evidence, including generating false evidence or persuading witnesses to change their evidence, and do not provide or offer to provide any benefit to witnesses dependent upon the nature of their evidence or
Professional ethics, as defined and defended by the SRA, are highly relevant to the gathering and production of evidence in court, as they ensure the reliability and credibility of evidence, promote fairness and justice, protect individual rights, and maintain public confidence in the legal system. While the process of evidence production in court is determined by the civil procedure rules of the relevant jurisdiction, evidence production in party-driven processes, like arbitration, can become a lot more complicated. Like in a trial, alternative dispute resolution processes, especially a final determination process like arbitration, will involve preliminary steps and expedited procedures, allow parties to make written and oral submissions, and require the production of evidence by experts, advisors, and witnesses. While habits and systems developed in the civil litigation environment inform alternative dispute resolution processes, there will be differences with the litigation, especially in modes of conducting hearings and post-hearing proceedings, confidentiality and privacy in proceedings, and the origins of applied rules of evidence. In this section, we are looking specifically at the process of evidence production in arbitration.
Based on Section 33 of the English Arbitration Act of 1996, the tribunal has a series of general duties it needs to abide by.
The object of arbitration is to obtain a fair resolution of disputes by an impartial tribunal, without unnecessary delays and expenses. In this respect, one could argue that the Arbitration Act mirrors the overriding objective of the civil procedure rules. The way in which the tribunal meets this objective is by acting fairly and impartially, and adopting procedures suitable to the circumstances of the parties. Key within this is a duty to give each party a reasonable opportunity to present their case and deal with that presented by their opponent. It will not be considered reasonable to make lengthy oral submissions or to present any evidence that party wishes.
It will be the job of the tribunal to guide the parties on evidence, production, and procedure.
While the style of proceedings, be it adversarial or inquisitorial, may be subject to the wishes of the parties, the tribunal will need to consider whether documentary evidence, production, or oral submissions would be suitable in the circumstances, and whether hearings should be used or not. It is important to note here that arbitration's key principle, party autonomy, is still subject to an overriding public policy consideration that has to do with the effective administration of justice. Article 19 of the UNCITRAL Model Law provides that parties are free to agree on procedure, but this is still subject to public policy safeguards, as noted in Section 1 Arbitration Act, 1996.
How should we understand then limits on party autonomy?
A key limitation in the interests of justice or public policy will be the principle of equal treatment.
This is an imperative recognized by institutional rules and international instruments that the tribunal needs to respect, irrespective of the wishes of the parties.
If they fail to do so, then any resulting award is subject to challenge. New York Convention 1958 Article 5, which covers the situation that the party against whom the award is invoked was not given proper notice of the appointment of the arbitrator or of the arbitration proceedings, or was otherwise unable to present his case.
The same result is achieved through institutional rules. For example, the American Arbitration Association's Commercial Arbitration Rules, Rule 32, which states that a claimant shall present evidence to support its claim.
The respondent shall then present evidence to support its defense. Witnesses for each party shall also submit to questions from the arbitrator and the adverse party. The arbitrator has the discretion to vary this procedure provided that the parties are treated with equality and that each party has the right to be heard and is given a fair opportunity to present its case. In addition, it is important to remember that the parties cannot exceed the legal boundaries of the seat of arbitration, the legal space within which the arbitration is procedurally positioned, and cannot give the arbitrators rights to do things that are contrary to public policy or beyond their legal powers. For example, if oaths can only be administered by public officers, the arbitrators cannot take this over, no matter the wishes of the parties. Finally, one needs to be mindful of institutional rules, such as the AAA ones mentioned above. These may impose limitations on the rights of the parties. Section 34 of the Arbitration Act, 1996, contains a non-mandatory set of rules to help parties and tribunals organize issues around the production of evidence.
By evidentiary matters, we mean the time and place of proceedings, languages and translations, the type and content of written statements, disclosure and production of documents, questions to be put to the parties and the rules of evidence, covering issues around admissibility, relevance, weight, form, whether they are on matters of fact or, as mentioned already, whether the tribunal should take the initiative in ascertaining facts or legal issues or not is also to be decided. A set of practical issues for the tribunal to consider will also include whether confidentiality agreements are required, whether there are any preliminary issues to decide, and of what type, whether written submissions should be exchanged sequentially or simultaneously, how the production of documentary evidence will be handled, and how the
timing of witness statements replies to them, and their form will need to be considered. Timescales for oral statements, including the need for a pre-hearing conference and whether they are needed, will also be an issue to determine. Practical issues such as bookings, rooms, timescales, administrative support, and so on will also need to be addressed. All in all, the entire raft of issues that the Civil Procedure Rules takes care of in the context of civil litigation is up for determination by the tribunal and the parties subject to the overarching requirements of the arbitral seat. Specifically in the issue of experts, unless otherwise agreed by the parties, Section 37 Arbitration Act, 1996, the tribunal has the power to appoint experts of legal advisors to report to it, and can appoint assessors to assist on technical matters.
It is important to remember, however, that the tribunal will reach its own decision, which cannot be delegated to the expert.
Where the parties wish to bring expert evidence, they should obtain direction from the tribunal to determine the form the expert's evidence should take, how many experts can be allowed, and so on. It will be common for the experts to provide a written report with clarification, if necessary, offered orally at hearing. The fees and expenses of the expert or assessor appointed by the tribunal form part of the costs of the tribunal. Of course, the information above should not create the impression that dealing with procedural issues and evidence production makes arbitration an unmanageable task. Most arbitrations will take place under institutional rules that have streamlined processes and even provide for fast-track procedures, depending on the type of case and the needs of the parties.
For instance, Article 9 of the London Court of International Arbitration Rules provides for the expedited formation of arbitral tribunal, and under Swiss rules, arbitrations can be put on a fast track by adopting simplified procedures.
These might include a sole arbitrator, written statements, claims, counterclaims, and replies, and a single hearing. There is, however, one key problem with privately organized proceedings such as arbitrations that one does not encounter in the litigation context.
An arbitral tribunal lacks enforcement powers and cannot compel actions, never mind those of third parties out the contractual link that establishes and powers the tribunal.
Of course, parties are obligated to cooperate with the tribunal's instructions. Under Section 40 Arbitration Act 1996, this is a mandatory provision. The parties must do everything necessary for the proper conduct of the proceedings.
When a party fails to comply, the tribunal may make an award dismissing the claim or reach a decision on the basis of whatever evidence is available already. If a witness is beyond the control of one of the parties, however, they could choose to ignore any request from the tribunal.
As a tribunal does not have its own power to require the attendance of witnesses, it has to apply to the court. The Arbitration Act, Section 43, does give the power to parties in arbitral proceedings to use the same court procedures available to those in legal proceedings to compel the production of documents or the testimony of witnesses. For this request to take place, the tribunal needs to give permission, or the other party. The witness needs to be in the UK, and the arbitral proceedings need to be taking place within the jurisdiction of the court, meaning in England, Wales, or Northern Ireland. Also, remember that a person cannot be compelled to produce privileged documents, meaning information that could not be requested in the context of civil litigation. If the parties and the tribunal want to use this facility, Section 44 Arbitration Act, 1996, the court can exercise on behalf of the tribunal the same powers in arbitral proceedings as they could in the context of legal proceedings.
Of course, this is a facility used only when necessary, as the whole point of arbitration is to offer an avenue for the resolution of disputes outside the remit of the court.
The matters in which the court can intervene include the taking of evidence, preservation of evidence, orders to secure access to property, as well as a range of interim injunctions. In the field of international commercial arbitration, a common system in the domain of evidence is provided through the rules on the taking of evidence in international arbitration, devised by the International Bar Association. First published in 1999, the IBA rules provide mechanisms for the gathering of evidence and the presentation of evidence in international arbitration proceedings, and are often described as reflecting a compromise among the approaches from different legal systems. They are designed to provide procedures for the efficient, economical, and fair taking of evidence in the course of an arbitration, and have been widely influential in practice since they were promulgated. The IBA rules include specific mechanisms for the presentation of documents, fact, and expert witnesses, as well as the physical inspection of evidence and the conduct of evidentiary hearings.
They may be adopted by parties in whole or in part, or as guidelines, either in an arbitration agreement or after a dispute has arisen, and are intended to supplement the legal provisions and institutional or ad hoc rules that apply to the conduct of an international arbitration.
A revised set of IBA rules came into effect on the 29th of May, 2010. Further, the IBA Guidelines on Party Representation in International Arbitration, 2013, provide guidance on the ethical considerations that lawyers should consider when representing their clients in the production of evidence in arbitration. This includes ensuring that evidence is produced in a fair and honest manner, avoiding conflicts of interest, and respecting the confidentiality of the arbitration process. This presentation introduced you to the production of evidence in arbitration and explained how it differs from that in a court process. In arbitration, the parties involved have more control over the process, and the rules governing the production of evidence can be more flexible and adaptable to the specific needs of the parties and the dispute. One key difference is that in arbitration, the parties have greater control over the selection of the arbitrators and the procedural rules governing the arbitration process. This allows the parties to agree on specific procedures to produce evidence, including the scope of evidence, the timing of disclosure, and the rules governing the admissibility of evidence. Another key difference is that the rules of evidence in arbitration can be more flexible than in court proceedings.
For example, the parties can agree to use different types of evidence or to waive certain evidentiary requirements.
This can help to streamline the process and reduce costs. In the domain of international commercial arbitration, the International Bar Association (IBA) has developed rules and guidelines to assist parties and arbitrators in managing the production of evidence in international arbitration. The IBA rules on the taking of evidence in international arbitration provide a framework for the parties and arbitrators to agree on procedures for the production of evidence, including document disclosure, witness evidence, and expert evidence. By understanding the differences between court and arbitral process, parties involved in arbitration can make informed decisions about how best to manage the production of evidence in their dispute.
Thank you for listening to this podcast.
Click one of the options on your screen right now for more key content for your SQE preparation. Thank you and see you next time.